Okay, I'd like to welcome you on behalf of the Missoula League of Women Voters and the University of Montana Law School to a series of forums on the judiciary. We have funding from the League of Women Voters of the United States Education Fund and from the Constitutional and Legal Policy Program of the Open Society. I wanted you to know also that the series have been approved for continuing legal education credit for anyone who happens to know an attorney or someone who wants to get a few extra credits for their continuing legal education. Each session will be up for 2 credits. There is a table at the door, and on the table there are pens and paper and programs. If you didn't pick one up, you might want to pick one up on your way out. The pens and the paper are there for you to write questions, because we will start with some presentations from these 2 lovely ladies, and then we will have a couple of questions that have been pre-approved for me to ask, and then the mic will be open for questions from the floor. So if you have a question, jot it down, try to make it as concise as possible so that we have plenty of time for lots of questions. And then if you come to the center aisle, you can use the mic and everyone can hear your question. And also, MCAT, who is doing the filming for us, will also be able to get your question on tape. So first, I'd like to introduce our 2 presenters this evening, if I can find the stuff.
Or I can introduce you and you can introduce me.
You have a little bit of their biographies in your program, and I will just go ahead and introduce them from there, and you can look up if you want a little bit more information. The lead presenter tonight is going to be Professor Cynthia Ford, who teaches civil procedure and a number of other classes at the University of Montana Law School. And helping her, working with her, is Professor Maylin Smith, who is also a professor at the University of Montana Law School and is the director of the Indian Law Clinic. So she's going to talk a lot about tribal courts, which I think probably most of us don't know very much about. And I am going to just let these 2 ladies go ahead, and Professor Ford, you want to begin?
And Maylin and I are going to actually do this together, jointly. I know something about tribal courts. She knows a lot about state and federal courts. And so we're going to talk about all of them. We're going to chime in back and forth. And usually we would have questions whenever they occur to you, but I think because of the filming, you can't just stick your hand up. You have to actually stand up. But if you have a question partway through, you're welcome to ask it right then, so long as you approach the microphone to ask it so it gets on the TV, I think is what we want to do. Pardon?
And turn it on.
That would be key as well. Maylin and I share a lot of things, and I think we both feel we're lucky to be each other's colleagues. We also share child raising. I have 2 kids. She has 2 kids. Our kids go back and forth. And not one of the 4 has ever heard us referred to as lovely ladies.
That's right. Yes.
A lot of times when they're complaining to me that they've got the wrong mother, they certainly want to go live with her, and then
vice versa as well.
So we're used to working together, and that's how we intend to do it here today. What we've put together, and I would say Maylin actually took the lead on this, is a little PowerPoint just so you can see visually the subjects that we are going to talk about. What we are going to talk about today are the 3 court systems which exist in our country. One of the courses which I teach is called civil procedure. It's, I say, how you run a civil lawsuit. And all the national public civil procedure books, which you can buy and have your law students study, and they cost about $100 and they look like that, they start out with this whole paragraph about what a great country we are because we have these 2 court systems side by side, the state court system and the federal court system, and what an extraordinary thing it is for a country to have these 2 independent court systems, one doing one job, the other doing the other job. But in fact, they're all wrong, because there are 3 court systems which, there are 3 court systems in our country which exist side by side. And they're really because there's 3 separate sovereigns. So that If in the United States territorially, we have the tribal court system, of which there are 300 and...
Tribal courts, there's probably about 180 tribal courts. There's over 555 tribes that may have some form of dispute resolution. But actual court systems, there's about 180 tribal courts.
So a lot of times my law students say, oh, the tribal court system. Well, there isn't a tribal court system, just like there is not a single state court system. On the right,
Yeah.
on your right, it says state, but of course there are 50 separate state court systems. Each state has its own court system, just as each reservation has its own court system. And then in the middle, we're going to talk about the federal court system, and that is a single unified court system which operates throughout the country. And the way we're going to approach these is go through them one by one. We're going to start with the federal court system because it is this single unified court system. How many of you have ever had any experience in federal court? Were you on a jury or litigant? Observer. How about you? Jury? Criminal or civil cases? Civil cases. And if I ask that question and you were a criminal defendant and you don't want to talk about it, don't stick your hand up. Okay? Sorry? Oh, okay, so you got to the voir dire process in the jury. Nice. Anybody else on this side? Judge Orsic? You took the judge to lunch. We'll talk about that in a minute. Did you get anything for that? No. Not at all. Okay, good. Judge Orsic?
I used the federal court when all the state rooms were booked.
Perfect. So we've got...
I got to use the federal court.
Okay, and we've got... So we have a lot of people out of this small, really a small sampling, who've got personal experience one way or another in federal court. And that is a great thing about Montana, isn't it? So many of our courts, all of our courts, are so accessible to us. And you know that the federal court is just a block this way down in the new federal courthouse. It used to be above the post office, but now it's right there. And in that courthouse sits the federal district judge for the District of Montana. So that the federal system has 3 tiers: Supreme Court, U.S. Supreme Court at the top, then the courts of appeal, the circuit courts of appeal. There are 11 circuit courts of appeal, plus the District of Columbia. And every time I do a presentation like this, I have to go look the number up. This time, Maylin did that. But I really am always going, are there 12 or 13? There are 12, but it's tricky because they count to 11 and the District of Columbia. Anybody know which circuit we're in? Ninth Circuit, great. And the federal district courts, there is at least one federal district for each state. Many states have more than one. We have one here in Montana. There's the United States District Court for the District of Montana, the entire district. In Washington State, they have 2, the Western District of Washington and the Eastern District of Washington. I think the largest federal district in the country is California, where they have a northern district, a central district, and a southern district. I think that they have 3, and they have a huge number of district court judges. So we've ranked them from the top down: Supreme Court, courts of appeal, circuit courts of appeal, and then the federal district courts. I want to start talking about what they do by starting at the bottom. The federal district courts are the courts of general jurisdiction in the federal court system. That means that they hear almost all the cases which are assigned to the federal system you can take to the federal district court. You chime in.
No, you're doing fine at this point.
Okay. So in each district, there are a specified number of judges, which depends on the population of the district. In Montana, we have this enormous district geographically, but we only have 3 what we call Article 3 judges. Article 3 refers to the article of the United States Constitution which sets up the judiciary. And that provides that federal judges are appointed by the president, as I say in my classes, in Washington, D.C., way back there. The president appoints each federal judge. That judge is appointed for life or good behavior, whichever comes first. Generally, it's life. And Judge Malloy didn't let you influence his decision, so he gets to stay. So in Montana, we have 3 Article 3 judges, one of the very smallest districts in the nation, even though we have one of the biggest geographical areas. The chief judge for the United States District Court for the District of Montana actually is located here in Missoula, and he is Federal Judge Don Malloy, who sits over here in this courthouse. And administratively, he's in charge of the district, although he ranks in terms of the strength of his decisions and the power of those decisions equally with the other 2 Article 3 judges. The other 2 Article 3 judges, one of them sits in Great Falls, Judge Sam Haddon. Any of you know him when he was a Missoula lawyer? Sure. And when he got, we call it when he ascended. He is, you know, you can say whether he ascended or descended, but now he lives in Great Falls. So he actually lives in Helena, but he sits in Great Falls. That's where his primary chambers are. And then the third Article 3 judge is a judge down in Billings known as, or his name is, Judge Rick Siebel. And he's currently famous because he handled the case, I think the biggest case that's out in the news that he did was the cattle case from Canada. And I think he originally ruled in favor of the American cattle people to keep Canadian cattle out. The Ninth Circuit reversed it, and he just recently had that case again. And I think he said, I really want to help you out, but I can't, because my bosses up at the Ninth Circuit said this is the law, and I have to obey the law despite what my own personal predilection would be in this particular case. Before we go on to talk about the Ninth Circuit, I want to talk about the magistrate judges. There didn't used to be magistrate judges. They actually are an offshoot of the increased federal caseload. The federal judges about 25 years ago really were overwhelmed by all the cases they had, and Congress enacted a statute allowing each district to employ some magistrate judges. The magistrate judges then are not appointed by the president, and they don't have a life term. Instead, they're appointed by the district court judges. All the Article 3 judges make the appointment, and their term is an 8-year term. Currently in Montana, it says 5. There are 3 full-time, I think.
Right, and there's a couple of part-time.
Couple of part-timers. The 3 full-time magistrates, one right here is Bart Erickson. Anybody know him? Yeah, and he's about to retire. I think in May is when he steps down. But he served 2 8-year terms. He used to be a state court judge up in Flathead County, and then he got appointed to be the magistrate in 1991, and he's been the magistrate right along. When he got that job as the magistrate, I was seeing him one day, and he said, you know, this is just a great deal. He said, I was a state court judge, I had these horrible cases, and I had to decide between life in prison or the death penalty and all these terrible murder cases. And he said, and now, you know, my full criminal authority, $50 for cutting firewood in the federal forest. And he said, and when I was a state court judge, I made $60,000, and now I'm making $125. Isn't this a great country? So he's been a great magistrate, but he is stepping down. And they just appointed a new one. The other magistrates who are full-time is Judge Carolyn Ostby. She's over in Great Falls. And there's Judge Rich Anderson, who's down in Billings, and I think that he also is going to retire in June or July or whenever his term is next up, and then they'll appoint a new one for that. And the name of the new magistrate who will be coming here, thank you, Jerry Lynch.
I was going to say,
Yes.
starts with J.
Yeah, Jerry Lynch. So he'll be coming here. He used to be a lawyer up in Great Falls, but now he'll be taking over this seat. So the job of the federal magistrates is very limited in terms of criminal work, what they can do. You're entitled as a criminal defendant in the federal system to have your trial before an Article 3 judge. And that really does take up a lot of the time of the Article 3 judges. We're going to talk about what kinds of cases the federal courts can hear, and we'll talk about what kinds of crimes and so on. But as more and more things have become federal crimes, the caseload of the federal judges adjudicating those criminal cases has really skyrocketed to the point where they really didn't have time to get to the civil cases, because there's a constitutional right to a speedy trial in a criminal case. does not exist in a civil case. So if you've got these two piles of cases to work on, this one says go fast, this one says when you can get to it. So civil cases we're getting further and further behind. And the federal magistrates have picked up a lot of that caseload. You still have a right in a civil case to have your actual trial before an Article III judge if you wish. But there's also a provision that you can consent to have a magistrate judge do the trial instead. And we're so lucky in Montana so far that our magistrates have been terrific trial lawyers who are terrific judges. So most people do consent. So they do actually process a lot of the civil cases right to conclusion, which has been a tremendous help for our federal judges. We actually got our two newest Article III judges, Judges Siebel and Haddon, were the first appointments made by this president, because we had lost our two other federal judges, and so Judge Malloy was having to carry the entire caseload of the whole district himself. And if you looked at him, you could see that that was going to be an early death. So he actually looks quite a lot better now that we have these other two judges who are out there. Anything else you want to talk about? There's another set of federal courts which also operate at the beginning trial level where you come in and file your case. And they're divided up by the kinds of cases which they can hear. So there's a special bankruptcy court that does nothing but federal bankruptcy cases. And as we'll see in a minute, actually all bankruptcy cases are federal. You have to go to federal court. And you can't go to the district court, you have to go to bankruptcy court. The bankruptcy judge sits in Butte, but he also was a Missoula lawyer, Judge Ralph Kircher, and does nothing but bankruptcies. He governs the entire caseload for the District of Montana in bankruptcy cases, largely using technology, so that not everybody has to drive to Butte anymore to make a 15 or 20-minute appearance. He does a lot of it by video teleconferencing, which has really worked out well. There's also a military court, about which I know nothing. There's the Court of Claims, and one of the judges on the Court of Claims is a Montana lawyer as well. And then there's patent courts. So if you have one of those specialty cases, you have to go to one of those courts. The bankruptcy court there is a bankruptcy court in every district, including in Montana. But there's not. The Court of Claims is back in D.C., and the patent court you have to go back to D.C. to do too. Anybody have any questions about the structure of the federal courts?
You forgot the federal tax court that one of our lawyers sits on.
And the federal tax court that one of our lawyers sits on. And
technical tax appeals.
And technical tax appeals. Exactly. So, perfect. When many of, and we have Judge Orzik, who's a sitting justice of the peace here, and she's going to help us with the courts of limited jurisdiction, and Abe knows a lot about everything, I think. So, chime on in. I did want to take a few minutes and talk about federal subject matter jurisdiction. On the criminal side, in federal court, you, of course, hear federal crimes. All of those accusations of violating federal criminal statutes. Obvious one is kidnapping across state lines is a federal crime. There used to be very few federal crimes, and increasingly over the last 20 or 30 years, more and more things have become federal crimes. Lots of times the same conduct is both a federal and a state crime. Anybody think of a recent example? Meth across the border, yeah, drugs. The Rodney King beating case. Remember, they tried to prosecute him in state court, and then they prosecuted him again in federal court. And that's not double jeopardy because they're two separate systems. And then there's another whole category of federal crimes which are federal crimes because they take place on Indian reservations. And they are listed under the Major Crimes Act, which is a federal statute, which gives exclusive jurisdiction. You better talk about this.
Yeah, the Major Crimes Act sets out a series of offenses that gives the federal courts jurisdiction when they occur in Indian country and involve an Indian defendant. So those are the crimes that are going to go into the federal system. They can be in the tribal system as well, but they also can go into the federal system under the Major Crimes Act.
But they don't go to state court.
They do not go to state court.
I'm more comfortable over here because I'm a civil trial lawyer, not a criminal trial lawyer. So here we are at civil cases which can be heard in federal court, and they break down into two kinds. Let me step back for a second and say this, that the federal courts are courts of limited subject matter jurisdiction as opposed to the state courts, which are general subject matter jurisdiction. And what I mean by that is the state courts I think of as open door courts. You can go in anytime. You don't have to have an express invitation. They can hear almost any kind of case. In federal court, and I show this to my classes in law school because we close the door and then I go outside and I have to knock to get into federal court, and you have to show them that you deserve to be there, because the federal courts hear only very particular kinds of civil cases. And if you don't qualify, then you have to take your case somewhere else, to state court usually or to tribal court. The kinds of cases which you can hear in federal court are broken down. One category is exclusively federal. That means the federal law says these kinds of cases have to be heard in federal court. No other court system can hear them, not state, not tribal. And some of the examples are bankruptcy cases you have to bring in federal court, patent cases in federal court only, admiralty cases in federal court. And it actually, the statute is admiralty and prize cases. In the event that you're sailing the high seas and a pirate comes along and takes your ship, you have to go to federal court for that. You cannot go to Montana State Court for that. Then there's another category of cases in the federal courts which are concurrent with the state. That means either the state or the federal courts can hear those cases. It's up to the plaintiff, the person who's suing, to choose which court system that plaintiff thinks is best for this particular case. And the two main categories of subject matter jurisdiction, which is concurrent between the federal and the state court, are those cases which involve the interpretation, application of a federal statute or treaty. Those are called federal, or constitution. Those are called federal question cases. So anytime you allege that there's a violation of the federal constitution, federal law, federal treaty, you are entitled to take that to federal court. You also have the free choice to bring that case in state court if you wish. But if you choose federal court, you're fine to go in there. For federal question cases, there's no minimum amount. You can take a federal question case. If you say that someone's violated your constitutional rights and you were damaged $1, you can go to federal court. That's different from the second category, which is diversity of citizenship cases. In those cases, there's two requirements that you have to meet before you can go to federal court. One of them is that there has to be a diversity of citizenship. That is, the plaintiff has to come from a different state, has to be a citizen of a different state from the defendant. So a Californian and a Montanan in a lawsuit are entitled to go to federal court because they have diversity of citizenship. But a Montanan versus Montanan, not. Idaho versus Idaho, not. California, California, not. If I sue these two people, and I'm from Montana and you're from Montana, but you're from Ohio, we do not have diversity of citizenship. There has to be complete diversity. That means nobody, you know how the court captions are set up, plaintiff versus defendant. Everybody on this side of the V has to be from a different state from everybody on this side of the V. So in that case, if I really, really wanted to go to federal court, she's from Montana, I'm from Montana. She's from Montana, he's from Ohio. Which one should I drop from my lawsuit? Her, right, I'm going to drop out the Montanan. Now it's Montanan versus Ohioan, person from Ohio, and I can go to federal court if I meet the second requirement, and that is a monetary requirement. In order to get into federal court, even if you have diversity of citizenship, you have to have at least $75,000 as the amount in controversy, exclusive of interest and costs. It used to be, back when I started practice, and that actually turns out to be quite a long time ago, there was no minimum. It was just like federal question. If we just had diversity, that's all we needed. But as the workload of the federal courts increased, Congress responded by making a basement amount for diversity of citizenship, trying to weed out diversity cases so there would be fewer of them. And I remember when it went from 0 to 5,000, and then it went to 10,000, and then it went to 15, and then it went to 25, and then it went to 50, and now it's at 75,000. And that's a compromise between a lot of the federal judges who really would just as soon have no diversity cases at all. They would just get rid of it altogether. And a lot of trial lawyers who really believe that you need to have this federal option in a diversity case. So tinkering with the amount in controversy is the way that they're titrating the caseload based on that. Anybody have any questions so far?
And I guess the other point, though, on diversity, since we didn't talk, she may be raising this later, is even though it's in the federal court system, they're still going to be applying state law. So they're actually sitting as a state court for all practical purposes, but it's the federal court system.
And so what that means when I say to my students is that means that the federal judge, even though he says, I'm federal judge Donald Malloy and I'm in the federal courthouse and I get a federal paycheck from the federal government, when it's time to decide the diversity of citizenship case, which can be a simple car accident. If we have a car accident, even in Montana, between this Ohio guy and me, and I'm badly hurt so that there's more than $75,000 at stake, I can go to federal court. But when Judge Malloy has to decide who was right and who was wrong, who has the right-of-way in the intersection, he turns around and he uses the exact same Montana statute book as Judge Orzik would use in the Justice of the Peace Court down here in Missoula County. So in diversity of citizenship cases, you don't get different law. The only advantage, and the reason that the Constitution allows for diversity of citizenship, is so that the case is somewhat removed from local politics. If you're from, are you from Montana originally in your whole life, sir? Where did you start?
Are you talking to me?
Yeah.
I'm from Missouri,
Okay, great. And how long ago did you move here?
1955.
Okay. And I'm not going to say show me. That would be too much. Show me. So when you move here in 1950, anybody from California here originally? Yeah, and I actually was born in San Francisco.
Not originally. I was born in Virginia.
Okay, so you went from Virginia to California to Montana?
Yeah, when I was 3 years old.
3 years old you came here?
No, 3 years old, I moved to California, and then in 1998, I moved here.
Great. So you've just been here since 1998?
Right.
All right, perfect. And in my classes, sometimes when I say somebody from California, you know, there's a couple of people who kind of go, I'm sort of from California. You think you either are or you're not. You know, if you are, stick your hand on up there.
I'm from California, but I live in Peel.
Exactly. Yeah. Exactly. And we all laugh and we think, okay, we know what that means. I was born in San Francisco. And where are you from in California, ma'am?
Orange County.
Nice.
Fullerton.
Okay. So,
Born in Los Angeles.
and how long have you been here?
Since 1969.
Okay, so you guys have each been here a long time, you lesser, so I'm going to count you. And when you came here, it's kind of hard to say out loud, I'm from California, isn't it? You just think maybe everybody's going to go, oh man, there's another Californian. That's the exact point of diversity of citizenship. So that if I stand up in front of the jury and I say, I'm from Montana, and I was hit and injured by this guy from California. I mean, I know he lives here, but he's really from California. And you know how they drive in California. And then they come up here, and then they raise our property rates and values. And you know Californians. How are you feeling as a jury of Montanans? You're kind of leaning towards me, yeah, a little bit. That's the worry anyway, is that the whole purpose of diversity of citizenship is to prevent discrimination by citizens of one state where they choose to bring the lawsuit against somebody who happens to be of another state. The jury pool is the same. Whether you're in state or federal court, you have Montanans sitting on the jury pool. But the control is the judge. A local judge is elected, as we're going to see, or appointed. Either way, quite a political process. And it's usually for a term. So if even though the elections are nonpartisan, if a bunch of people started saying, boy, that judge there, he always rules for the out-of-staters. We get a chance to vote for him. We're the in-staters. You know, it's pretty easy. She says, my platform is I vote for in-staters. Heck, we vote for her. So if you're going in a court where the federal judge is appointed from Washington and once appointed is insulated from the political process because he or she, in Montana, we're just going to say it right out loud, he, the federal judge is in Montana, because he has his term for life, he doesn't much care what the rest of us think about whether or not someone from California should get a fair shake here. So that's the purpose of diversity of citizenship. To delocalize the control of the court system and give someone from out of state a chance at a different system. And, different judges are different ways. So what this does is it allows the plaintiff to choose in the first instance whether or not the plaintiff wants to go to state or federal court, so long as there's diversity and the amount in controversy is more than $75,000. Anybody have any questions or comments? Yes, ma'am.
When you refer to state courts, are you talking about Montana State Supreme Court or district?
The whole state court system.
Okay.
And we're going to talk about that in a second. Perfect. Anything else about federal courts? Questions, comments?
Why do people do, they don't have the 75,000, they just not go to that diversity of citizenship?
Exactly. They go to state court or, in some cases, tribal court. Right. Mm-hmm. So there's always a place to get your case heard, but you have to decide if you meet the requirements for a particular court system. Yep. Great. And now we're going to turn to the state court system. We're going to look at Montana as an example. And of course, every state has its own court system. So if you were to go to a different state, Missouri, you'd have to look in their statutes and constitution to see how their court system is set up. So I am going to talk now about the Montana state court system. And again, we start at the top and work down. There's the Montana Supreme Court. Sits in Helena. How many justices? Do you guys know? 7. And it used to be 5, then they upped it to 7 for a limited period of time, and then I think they got rid of that sunset provision, so now it's just permanently 7. I tried, Maylin started the PowerPoint deal, and then I came along and made some more slides later, and I tried really hard to get a photograph of the Montana Supreme Court off their website onto this PowerPoint, but that is more than I know how to do. So you can picture them, we'll describe them later. The district courts are the courts of general jurisdiction in the Montana state system. So almost all cases begin, that's not true. To get into the state court system, you generally begin in the district courts. And then if you don't like what happens to you there, you appeal to the Supreme Court. Then below the district courts are another set of courts called the courts of limited jurisdiction. And there are several separate courts that deal with that. Each county has at least one justice of the peace, and that's required in the Montana State Constitution. It was in the 1789, I'm sorry. That was the other one, that was the big one. 1889 Constitution. I'm originally from Connecticut, where things really were in the 1789. I've been here a long time, but not that long, apparently. Okay, so the 1889 Constitution said there's going to be a justice of the peace in each county. When we had the 1972 Constitutional Convention, there was a lot of discussion about maybe not having justices of the peace anymore, and the Constitutional Convention said, no, we want them. So there still is, even in our new Constitution, a provision that there's at least one justice of the peace in every county in Montana. Additionally, there are city courts in cities or municipal courts, and we're going to talk about each of these in turn. The slide is, the water court is limited jurisdiction, but statewide, and it's limited in the kinds of cases which it can hear. It only hears water rights cases. So I think it's set up in Bozeman, and that's where you go if you have a water rights case, but it adjudicates water rights cases from all over the state. There's also a workers' compensation court. Judge Jim Shea, who used to practice here in Missoula, was just appointed to be the workers' compensation judge. There's only one of those in the state of Montana, and he decides all workers' compensation cases from around the state. And the legislature recently authorized another kind of court, the asbestos claims court, but that hasn't actually been set up and funded yet. It's allowed, but it's not functioning yet. And I wanted to talk about the courts of limited jurisdiction first. They're at the bottom. It's not clear to me why that's in blue, but it is. These are the ones I did. They came out in blue. That's why it's in blue. But the courts of limited jurisdiction are courts whose jurisdiction is limited to what we think of as smaller cases. That's smaller in terms of dollar value, usually. And they're comprised of the justice courts, the city courts, and the municipal courts. There are 66 justice courts around the state. Some counties have more than one justice of the peace in each county. Like, which county? Missoula County. So Judge Orzik is one of them, and then Judge Odlin is the other of the 2 justices of the peace whom we have here. Some places have many counties have just one justice of the peace, but that's why there are 66 and only 56 counties. Additionally, there are 81 city courts in Montana. So each local government big enough to be a city has either a city or a municipal court, and I'll tell you what the difference between them is here in a minute. There are 81 city courts and 5 municipal courts. The 81 city courts often have the same, some of them have the same judge as the justice of the peace. Some judges serve as both justices of the peace and city court judges in those counties and cities that don't have such a big caseload. There's no chance that our justices of the peace would have the time to go do city court kinds of work. And there are 5 municipal courts: Missoula, Billings, Kalispell, Bozeman, Helena. Is that what you think, Karen? Yeah, I think those are the 5. City court and municipal court are different this way. They're each in cities, but the justice of the peace and the city courts are one way, and the municipal court is the other way. To be a court of record in Montana, that is where there is a verbatim transcript of what goes on in the court proceedings. You need to be either a district court or a municipal court. And in those 2 courts, the judges have to be lawyers. They have to be law graduates. In the justice of the peace and city courts, there's not a court of record, so there's not a verbatim record, although there certainly are written records of what goes on, but it's not verbatim. And the justice of the peace and city courts are not necessarily staffed by lawyers. There are some city judges and some justices of the peace who have graduated from law school, but the vast majority have not. And that is because they were designed in the first place to be people's courts. People's courts where you could go in, you could get a common sense resolution of your dispute quickly and inexpensively. And you didn't need all this highfalutin stuff that comes with municipal courts and with district courts. And there is a great piece of bedtime reading in the Montana Law Review about 5 years ago entitled Civil Procedure in Montana's Limited Jurisdiction Courts. I wrote that. It's really good. And I surprisingly, I have a lot of extra copies should you want one. It wasn't a big seller. I'm giving them away now. Or you'll find them in various outhouses as toilet paper, whatever. But I talk in that a lot about the history of the justice in the city courts. What's interesting about these courts, all of them, is that they're called courts of limited jurisdiction. Some people call them the lower courts, but that's really not at all accurate. They have a limited amount of jurisdiction, but they have an enormous caseload. And as I say down there, the caseload is nearly 10 times greater for these judges than in the district courts. And people think of the district courts as the courts where you start most of your lawsuits. But instead, my research, and this comes right from the Montana Supreme Court website, suggests that most cases in Montana, most civil cases, begin and end in the city and justice courts. So they're far more important and powerful than that name lower courts would suggest, and that's why I don't use that name.
Well, would the justice courts be the closest thing to common law?
Yeah, I mean, they come to us, as I say, from Oldie Englandy. You know, that was the idea, that there was somebody right there in your community immediately available to resolve disputes. And that is the primary purpose, of course, of courts, is to resolve disputes. We have to have some organized system in which to do that, or otherwise every time Maylin and I disagree, we end up duking it out. And I'm far tougher, so she would always lose. This way, she can go to an organized system and present your case to an impartial fact finder who applies the law, the rule of law. Yeah. Yes, ma'am.
Are the justices in Missoula, are they lawyers?
They are not. Karen was a biologist. Judge Orzik was a biologist before she went on the bench, and Judge Odlin was a highway patrol officer before he went on the bench. I'm thinking there's only 3 or 4 justices of the peace who have full-on legal education, but before they actually they get elected, and then before they actually take the bench and begin ruling on cases, there's some pretty stringent training. And then during the course of their term, they have to go twice a year. It's a week, isn't it, Karen, each time? So they have to go 2 weeks a year and I've been part of that, pretty stringent training with exams, and you have to pass the exam. And I know of one justice of the peace, when I was giving a talk at one of those trainings, who left, 45 minutes early or something, because his son was graduating from an educational institution, and so he went to see the graduation. And I mean, they suspended him. And then he had to write me a letter of apology, and then he had to write a little essay, and I was going, oh my God. But they take that certification and the continuing education so seriously, I think, to make up for that. And what you find are people who really are dedicated to their jobs, and they choose to get into this, which is not an easy line of work. Judge?
About 80% of our judges in the courts of limited jurisdiction do not have law degrees.
Okay, so 80% out of all of them do not have law degrees.
80%.
You make them all read your article.
Oh yeah, that's required. There's a test. What the courts of limited jurisdiction can hear by statute is limited. They do misdemeanor criminal offenses. Felonies have to go to the district courts. The civil cases which they can hear are pretty much all civil cases, but the amount is limited. As we saw in the federal court, you have to have a basement amount of $75,000 for a diversity of citizenship case. In justice and city and municipal court, you can bring any civil suit, but the amount has to be less than $7,000. That's where we are now, $7,000. If it's more, if you have for $7,001, you have to go to the district court and begin your case there. When we get to the district courts, we'll talk about that. They have no basement amount, so really you could bring a civil suit in the district court, skip justice court, go to the district court for $3 if you want. I just had some guest speakers in my remedies class this morning, 2 people who do a lot of collecting, and one of them I said, if you have your choice, your free choice between justice court and district court, where do you go? And he said justice court. We'd rather go to justice court any day because it gets done fast, professionally. We get a result and we can move on with our lives. And if we go upstairs to district court, first of all, the judge is looking over, and again here in Missoula County, his glasses saying, why are you in my court for $3? They just don't think that they should have to do those low-end cases. And if you go into justice court, they know how to deal with it.
Same thing.
Sorry, yeah, exactly. Yeah.
But you have no choice.
Exactly, right. But still, you can look over your glasses and say, I'm sorry, why are you here for $3? Yeah. There's a small claims division of justice court. There's a small claims division of district court, too, set up in the statute, but I don't know anywhere that actually has one which functions. Do you? No. So if you're going to go to small claims court, you're basically going to small claims court and justice court. And the top amount there is $3,000. Small claims court, no lawyers. Unless one person, if I want a lawyer, then I have to ask you, and if you want a lawyer, then we can both lawyer up. But otherwise, you just go in and get that done. Landlord-tenant disputes, local ordinances, forcible entry and detainer, protection orders, and some issues involving juveniles and other matters. That description comes right off the Montana Supreme Court website. How does that correspond? What do you think your caseload is largely made up of in the civil side?
In the civil side, maybe 150 to 200 cases a year, on the small claims, and on civil, I have about 550 a year.
Okay, so
I think 5,500 per year.
5,500 on just your division of justice court?
That's right, 5,500.
So if you double that, we've got 11,000 civil cases in the justice courts in our county alone. And I think that is far more, maybe 10 times as much, as the 4 combined district court judges have for civil cases.
So I have between 8,000 and 10,000 cases a year, civil and criminal. Okay? And I understand that the district court judges have about 4 to 5.
District court has about 4,000 to 5,000 cases a year total, criminal and civil.
So there's about 22,000 cases tried to figure, I mean, by now it's probably.
There's 11,000 cases filed. They are not all tried. A lot of them are settled. A lot of them are just dismissed.
So 22,000 total cases between the two courts.
No, 11,000 between the two.
11,000 in the justice court, and you're thinking 5,000.
Somewhere between 5 and 6, I think I saw with all the different kinds.
Okay, our other,
Among the four
Oh,
judges.
it's 8,000 per judge. We have 2 justice court judges. So there's 16,000 cases between Judge Island and I. And then Judge Loudon, who's a municipal court
Right.
judge, I believe has 16,000 on his own. So there's 32,000 cases in the courts of limited jurisdiction.
courts of limited jurisdiction. Then when you get
Civil and criminal.
civil and criminal. Or are you just talking civil?
I'm talking both,
Right.
8 to 10,000, yeah.
Yep. And then in the district courts, Karen, you were saying, and this is Karen Townsend, who's the chief deputy prosecutor who does a lot of work in the district courts. And you're thinking in the district courts altogether in Missoula County, between the 4 judges, there's a total of 5,000 cases?
I think it's pretty close to 6 from last year. I saw the statistics for the last 4 or 5 years.
Okay.
They broke them down between criminal, civil, adoption, divorce, all of those kinds of cases.
But you can see, the courts of limited jurisdictions got a caseload like that, and it's not to say the district courts aren't working, but it's nothing like the flood of cases that hit the justice courts. And in Missoula, we do not have a city court. We do have a municipal court. And so Judge Loudon, who currently sits in City Hall, is he moved into his new chambers? His new courtroom? Yeah, okay, so he's got the new renovated courtroom, but he's a city employee, and he is a lawyer. He does have legal training, and it is a court of record there in the municipal court. The difference between a court of record, as I said, is where they record everything verbatim. So if you don't like the result in a court of record, you have something to show the higher judge, and you can say, right, here's what happened, and here's what's wrong with that, and that's why you should reverse this. If you don't have a court of record, so the justice of the peace courts and the city courts, that's not available. So instead, if you don't like what happens, when you go up to the district courts to appeal, you get a new trial. It's a trial de novo. You start all over. But, as I said, most of the litigants in the justice and city courts don't appeal. They don't go to district court. They don't say there was a mistake. They live with the result. So that's why I say that most Montana citizens begin and end their experience in the state judicial system with the courts of limited jurisdiction. So when you go to vote, for instance, because we're the League of Women Voters here, when you go to vote, you should not automatically say, it doesn't really much matter about who the justice of the peace is here. Let's talk about the big judge, the district court judge, because most of your neighbors and friends are going to end up, if they go to court at all, they're going to end up in one of the justice of the peace or the municipal court judge cases here. Okay. Any questions about the courts of limited jurisdiction? Anything else, Judge Orzik, you want to say? So we're lucky to have in this room, all of you have had some experience with the courts, and we have experts in the courts of limited jurisdiction. We have a criminal prosecutor who practices in both courts. Maylin, aye. And any of you who know anything, like Abe, that we don't know, chime in.
I think people file too in justice court because of the cost.
It's much cheaper.
It's like $20 or $35 depending if you go to small claims or justice court, whereas if you file in district court, you're going to pay, what is it, $135 in filing fee?
Yep.
And people, their cases are usually, they think of that when they file.
Yeah, I mean, it's a big difference. Yep. I also think the unsung heroes of the courts of limited jurisdiction are the staff people too. If you walk in to the Justice of the Peace Court, there are people working full on, full tilt, hard, keeping all of that organized, and they're pretty pleasant, which I think is an amazing deal. The district courts in Montana, so that's what we call the courts of general jurisdiction. They get to hear all kinds of cases. They don't have an upper limit. There are 56 counties, and there's a courthouse in each county. I'm actually about to embark on a project of photographing each of the courthouses and putting together a little book and showing who the judges are and so on, because we have so many beautiful courthouses around the state. But look at the difference here. 56 counties divided up into 22 districts. Which district are we? Do you know? We're the 4th Judicial District here in Missoula. And there's only, as of the 2003 statistics, 42 district court judges. And that's because some counties do not have a resident judge. Instead, some judges are assigned to several different counties in their districts. And so 42 is the most that we have. I spent some wasted time in my life practicing law over in Seattle. I thought I'd see how they did it in the big city. And and I was just there with the Montana trial team in the King County Courthouse in downtown Seattle. And I have a friend who's a judge there, and I asked her how many judges there were in that courthouse alone. And I think Karen was with me. I think there were like 62. So in King County in Seattle, which is, a city, but not the biggest city in the country, they have more judges than we have in our entire state. And that floored the judges when I told them that. The district court judges have to be lawyers, and as I said, they are courts of record. The district court judges are elected, and here in Missoula County we have got 4 district court judges. Three of them are going to continue on, and for the first time in a long time, we have one of those seats opened up. Judge Henson has announced his retirement. He gets off the bench.
March 31st.
He's off.
Oh, he's off. So
He's off.
So it's actually fair to say that there are 3 judges right now. We have Judge Harkin, Judge McLean, and Judge Larson. And then there's some contention about who gets this next seat. And I'm going to talk about how you fill judge vacancies pretty quick here. In the Missoula County opening, it looks as though the governor is going to have the opportunity to appoint for the rest of the term. Meanwhile, the seat will be filled permanently in the general election in November, and the primary is June 6th, and there are 5 candidates for that job. So you have to choose. So on June 6th, the election will whittle the field down from 5 to 2, who will then go on for the general election and be elected in November.
There's a good chance that the governor will decide not to come.
There is. And I think what I did was I put in another couple of screens because I thought you all might be interested just in how you get to be a judge. So I put in, because this was the League of Women Voters, so I put in a couple of screens about judicial selection and so on. So how about we talk about that in a second. I want to talk about the district court, the kinds of cases that they can hear. As I said, they're courts of general jurisdiction. So they hear all felonies. And you remember that the justice of the peace courts were limited to misdemeanors. They also hear all probate cases. You can't take a probate case into justice of the peace or city or municipal court. And then they have jurisdiction to hear almost every other civil case that you can think of. You have the right of access to the courts in Montana through the Constitution, and mostly that door opens you right up into the district courts. All civil cases which might result in a finding against the state, which would require the state to pay money to the plaintiff, have to begin in district court. That's another category you cannot take to justice court. Naturalization proceedings, but in Montana, most of those tend to occur in federal court.
Yeah, I don't know why.
Glory hogs. They're nice. Those naturalization proceedings, anybody been to one? Naturalization and adoption, I think, are the 2 cheery things that happen in courts. Otherwise, it's there's a lot of strife and contention. And when you go to the big city courthouses, as Karen and I have been around the country with the trial team that we coach at Montana, boy, it is a hard. We don't have nearly the misery in the Missoula County Courthouse, and we have plenty of it down there, as you see in these big cities. Naturalization, everybody's happy. Adoption, everybody's happy. And so I think that the federal judges don't get to see any adoption cases, so they grab the naturalization cases. And then various writs. And as I said, you appeal from the courts of limited jurisdiction, the justice and the city courts, to the county district court, and the trial starts anew. So that's another form of jurisdiction.
I think the other thing you left off are marriage and divorce issues.
Oh, marriage and divorce issues go to,
Must have been in the district
They're in district court, except the orders of protection, which are pertinent to, can start in the city and justice courts. But dissolution actions, marriage and divorce, go there. Divorce actions, actually, the justice of the peace is a frequent marrier. So they have the ability
To create it but not separate it. Yeah.
Exactly, they can do that. I once said about a friend of mine who was a predecessor to Karen, I said, if I ever get married again, oh, what did I say? Mike's going to marry me if I ever get married again. And I meant he was going to be the marrying person. I think he took it as, I'm going to marry you? No, I don't think so. And we skip in Montana from the district court where the trials are, where witnesses are sworn in, they tell their side of the story, the jury listens, decides who's telling the truth, what the facts are, apply the law that the judge gives them, and then comes to a result. That's the general trial level job. Many states have an intermediate appellate court, so you don't go right to the Supreme Court if you're unhappy with what happened below. Montana, we do not have an intermediate appellate court, so that where you go in Montana, if you do not like what happened over here in Missoula County, is you go right to the Montana Supreme Court. There are 9 justices. This was just to see if you were awake. Okay, 9 justices on the U.S. Supreme Court, 7 here. And they sit in Helena. They generally hear not very many oral arguments in a year, and the ones which they do hear, they hear over in Helena. But our Supreme Court is pretty terrific in trying to reach out again to this big, big state we have by scheduling oral arguments occasionally in other places so that members of the public can come here. And we're having one of them Friday morning here in Missoula, over at the
Theater.
The Montana Theater.
Montana Theater.
That one just south of the music building at 9:30, I think it begins. Is that correct?
University.
That's the University Theater. I have to look this up every time I go to either of those places. The University Theater, the Montana Supreme Court is going to hear actual oral argument in an actual case. They come to Missoula so that the University of Montana students, the Missoula High School students, and all of us regular citizens can go and watch. And it's a terrific opportunity. So I urge you to go to that if you can. And the job that they do is appellate review of the district court decisions. They do not hear witnesses. All they do is, that's not right, all they do. What they do is to read the verbatim transcript of what happened in the cases below, both civil and criminal. They get from the party who's appealing, called the appellant, a list of errors which that appellant thinks the judge below made. And based on that, they decide if an error was made, and if so, if it was bad enough to change the result in the case. Sometimes, many times in fact. They will find that there was an error, but it was harmless error, doesn't change the result, and nothing different is going to happen. But a lot of times they find that there was an error and that it was big enough that the case should be sent back and retried. That's the job. It's a very cerebral job. They are not on the field of play. They are instead watching the tape the week or the month or, mostly the year after the actual trial began. And it's not a tape, they actually read it and then make their decision. There's quite a controversy about whether or not we should have an intermediate appellate court, as most states have. I don't know the exact division. Do you?
I don't have an idea.
Yeah. But certainly the Supreme Court advocates having an intermediate appellate court because they think of it as like a funnel. Just as most people don't appeal from the justice court to the district court, what the Supreme Court thinks having an appellate court would do would be to funnel that down. A lot of people would appeal to the intermediate appellate court and then accept that result without necessarily going to the Supreme Court. So it would cut back on their caseload. And I downloaded this. There's a great website, I have to consult my Palm Pilot, called Montana Courts, www.montanacourts.org, that has got really a lot of statistics and information about the court system. And that's where you see that great picture of the 7 justices of the Montana Supreme Court. And they do a report every year about their caseload. And this is specific to the Supreme Court. There are also statistics for the district courts. I didn't put all of those up. But this was just to give you an overview of how much work they have, which they say is the reason they need an intermediate appellate court. So this is from 2004, the latest report they've done. They had 564 cases which they carried over from the year before. Then there were 693 new civil filings, direct appeals 471. Original proceedings, that is where the case began in the Montana Supreme Court. It's a very limited number of kinds of cases you can do that. 222, that's how we got to the 693. And then they had criminal appeals, 189. No prosecutors get to appeal.
Well, sometimes.
Sometimes.
Rarely.
But generally, it's a defendant who was convicted below who's appealing in the criminal cases. On the civil side, either of the parties, if aggrieved below, can appeal. So they had 564 old cases carried over and a new addition of 882 cases. So the 7 of them were handling that number of cases, which is more than 1,400. Exactly why I do not teach in the math department. It's more than 1,400. And then they divided these up so we can see what kinds of cases they had. They actually, as we saw, the total number of new case filings is 882. They had 670 notices of appeal filed. That's where somebody said, we're going to appeal. And all you have to do is send in a little piece of paper, not a big deal. But then to perfect the appeal, there's quite a lot more work. And so only 10 of those dropped out. So there were 660 new appeals. 471 were civil and 189 were criminal. The Supreme Court has set up a mediation route in another hope to lessen the number of cases it has to decide. But you can see that they sent 234 cases to mediation. 44 of those went away then. So it's not a very big percentage. But some, it's still 44 less. But it's not what they were hoping for, I think, would be fair.
What kind of cases are sent?
Pretty much all civil matters there's mandatory mediation on that go up there.
But
You can petition, I know, but you can petition for reasons not to have it mediated, but you actually have to make the request to not mediate.
So that's their extreme preference, is to go through mediation and then only come out when you've been through and it's been an unsuccessful process. Okay, any questions about Supreme Court and what they do? Okay. Then this, I want to talk quickly about the selection of judges before we go on to tribal courts. And this is the selection of judges in Montana for the state courts. We already talked about the federal, and Maylin is going to talk about how tribal court judges are selected. There are nonpartisan elections for all judges in Montana. The term, once you're elected, varies. For the Supreme Court, it's 8 years. District court judges, 6 years. And of course, the Supreme Court races, all of them, all 7 seats, are statewide races. So those justices are carrying on their full-time work and then going, out to Broadus, up to Eureka, to go to all the political things that they need to do. And they do that even when they're not opposed. And I don't think that there's any opposed Supreme Court races coming up. But we've seen a couple of strongly contested cases in the last couple of years. The district court judges just run in their district. They get a 6-year term. And then all the other judges, like Judge Orzik and Judge Odlin and Judge Loud, 4-year terms. If there's a vacancy midterm, there are different ways to fill that. The Supreme Court and district courts are filled by election if the term has ended, and by gubernatorial appointment if there's a vacancy during the term. And that's where we are with Judge Hanson, who retired before his term was technically over. So what's supposed to happen, according to the Constitution and the statutes, is that the governor can make an appointment to fill out the rest of Judge Hanson's term fill out the rest of his term. But he doesn't just go out and say, okay, I'm going to appoint you, or who wants to be the judge. Instead, there's a Supreme Court commission called the Judicial Nomination Commission, which is made up of both lawyers and non-lawyers, who vet all the applicants for the job, do interviews, and then they, from the group of people who've applied, send between 3 and 5 names to the governor, and then the governor chooses from that shorter list. In Missoula, though, as you say, the timing is so odd that it's not necessary that the governor actually make an appointment before the primary, because there's 30 days, the Judicial Nomination Commission has 30 days from the time, 30 days to make their recommendation, and then the governor has 30 more days from then in which to make the appointment. And if both of those bodies used all that time, we'd be past the primary date. If the governor doesn't do his appointment or her appointment within 30 days of receiving the list from the commission, then the Chief Justice of the Montana Supreme Court makes the appointment. Regardless of who appoints, the Senate has to confirm the appointment here in Montana, just as we've seen in the federal advice and consent. If the Senate does not confirm, then the office is vacant, and we start all over again. Judicial Nomination Commission, governor appointment, senatorial. Municipal and Justice of the Peace judges are filled by appointment of the city or the county governing body. How did you get to be a judge? When Judge Morris died?
Judge Morris died. The county commissioners appointed Judge Jaworski for the remainder of his term, and then I ran against Judge Jaworski in the 5-person primary back in 1998.
Right. And then who perked out of the primary to the general? You and?
Gail Albert.
Okay. So the conventional wisdom is that it is extremely hard to defeat an incumbent judge, but that's not necessarily true when someone's just been appointed and they've only been on the bench just a little while before that. Then it's generally easier, and it's not impossible to defeat an incumbent, but that has not happened in the Missoula County District Court judges races as far as I know ever. Is that true? Anybody? Okay.
Professor, I have a question. If, in fact, the Senate has to confirm, and our Senate only meets every 2 years, do we have a committee that does that in the end, or how does that work? I mean, we're going to have an election before we have another round of legislature.
Isn't it the Judicial Committee for the Senate that does that?
The person just sits until they just sit until the.
Yes, that's exactly. I was thinking that I had a slide on that, but that's what happens. They sit till the next legislature.
And then only if they don't get affirmed, then they lose the.
Then there's a vacancy, right?
In this case, of course, there's an election between now and then.
Okay, well now I think we should move on to the tribal courts.
If a judge's 8-year term is up, a 6-year term is up, and he has to run again, and he's not opposed, you have a attaboy.
Right, or no. And they actually had an article in the Missoula, did you see this Sunday, about the 2 Supreme Court justices who are running against Mr. No, because you have a yes or no vote on the judges. And we have seen in Missoula, even for district court races, unopposed, where there have been people, private citizens apparently, putting little ads in the Missoulian about vote no on so-and-so for various things. Yeah. Judge.
I just have one comment to make about justice court judges, is they've set bail on felonies.
Right, so you...
And that's a big deal, because that's how people know me from the newspaper. They really don't know me from my misdemeanor work.
Right.
They know me from setting bail on felonies.
So that, should I commit a felony here, I would appear before you to have my bail set. Actually, I don't appear before you anymore.
By video.
I appear by video from the new jail, and then you set my bail, but then it's bound over, and the trial's actually in the district court. Exactly. Thank you. Any other questions or comments before we move to the tribal court system? Sir? Tribal court system?
This tribal court system. In Montana, there are 7 tribal courts. All of them have their own tribal court system. They all are going to be operated under tribal law as opposed to state law. There may be some federal law that kicks in because there's federal legislation that specifically says it has to kick in. So you have this separate sovereign power out there that can overlap with your county jurisdiction and your state jurisdiction. And it becomes quite complex when you're looking at who's got jurisdiction in certain matters between the tribal and the states and even the federal, depending on what the issues are in front of it. The tribes here have different schemes. I'm going to start with the Confederated Salish and Kootenai tribe. They're the closest ones to Missoula. They are what is called a Public Law 280 reservation, which means that they may have concurrent jurisdiction with the state in certain matters in the criminal area. That's the only tribe in the state of Montana where there's concurrent jurisdiction criminally with the state. The other tribes are going to be under the Major Crimes Act that we talked about earlier for the criminal matters, and those are going to go into the federal courts or the tribal courts. So the Confederated Session Kootenai is different than the other tribal courts in Montana. The other thing to keep in mind is the tribal courts are not necessarily what I would view as a court of limited jurisdiction, similar to your municipal or city or JP courts, but they're limited in what kind of fines they can impose by the federal government. So they're courts of general jurisdiction, but for criminal matters, they are limited to 1 year and $5,000 for the penalties that can be imposed in criminal matters. So that's where their limits come in, is what can be imposed as far as sentencing in criminal matters. There are no limits in regards to the civil cases. They can pretty much hear any kind of civil case if you can determine that there's jurisdiction, and we don't have time to go into that because the civil jurisdiction is incredibly complex within Indian country. So it's out there, but it's very, very complex. You have to, when you're looking at tribal things that you have to consider that you don't normally doesn't come into play in your state system, is you have to consider treaty rights. Those are the laws that are going to be in place that are going to be applicable. There's going to be some rights that flow from those that the tribes can be enforcing and can be utilizing. Then there's the tribal code, and then there's the federal statutes that are specific to tribes. Those all come into place when you're looking at the tribal court setting. Tribal court settings are far less formal, in my experience, and I think you're experiencing that now, than you get in the state setting. And the reason for that, I think, is they're more of a community type court. They're in that respect, I think they're similar to your JP courts, where they know the parties, they interact with all the parties. The rules of civil procedure that you have in the federal and state court system may be there, but they're not as rigidly adhered to, particularly if the parties are not represented by lawyers. The vast majority of cases in the tribal system are still heard without attorneys being present. So it's a less formal system. They also have alternative systems that are custom and tradition in a lot of court systems that you may not even know are there if you're a non-member or a non-Indian within their court system. So you are always have several sets of rules and requirements in the tribal setting that you're not going to have in the state setting. The other thing to keep in mind is criminally, they don't have jurisdiction over non-Indians within Indian country, and Indian country is defined by federal statute. So if you commit an offense within Indian country and you're not a Indian, you're not going to be in the tribal setting. You're either going to be in the state setting or you're going to be in the federal courts, depending on what reservation you're on. So that's a difference that you have in the criminal area. The other thing that they have that I think is somewhat different is they have appellate systems. Some of the tribal courts actually do have an intermediate appellate system. They may not always use it, but Blackfeet actually by statute does have an intermediate appellate system. The other tribes do not have intermediate appellate systems, but they all have tribal appellate courts that you have to utilize. Before you can address anything in the federal court system, you are probably going to have to exhaust all the court systems available to you in the tribal if it arises within Indian country. So that's something you also have to keep in mind. I don't know how to operate yours. I can move you.
When you said that if you were a non-Indian, what happens if you're like, I'm Blackfoot and something happened on the Confederate savings?
As long as you are a member of a federally recognized tribe, the tribe, wherever you are within Indian country, whether it's your reservation or another reservation, that tribe will have jurisdiction over you for criminal matters. Civil matters is much more complex. Actually, it's one of those sort of ironic situations where it's fairly clear in the criminal matter, and tribes probably have greater criminal authority right now than they do civil because of some of the cases from the Supreme Court that have made it incredibly complex to try and determine when the tribal court has civil jurisdiction and over who they have it. So it's much clearer in the area of criminal. So as long as you're an Indian, occurs within the Indian country as defined by federal statute, the tribal court has jurisdiction over you. And that would be true even if it's a felony. If it is a felony, most tribes are not going to exercise that jurisdiction, that concurrent jurisdiction with the federal government, because of the limits they have on what penalties can be imposed, the $5,000 in 1 year. They're going to want the federal government to take jurisdiction. If the federal government doesn't take jurisdiction, though, the tribes are going to take jurisdiction. So there are tribal courts that are handing sentences down in murder cases because the federal government has not prosecuted. So they may only be able to allow 1 year and $5,000, but they are hearing murder cases in the tribal courts. So the system, the structure is very similar to what you have in either the federal or the state system in regards to the lower court. Most of the tribal courts are courts of record. Getting that record may be a challenge, but they technically are courts of record. So the funding sources, they don't have the court reporter, most of them, they're taped. So it's a matter of getting those tapes transcribed, and that's usually where the problem comes in, is getting somebody to transcribe those tapes. But they are appealed up based as a court of record. And you can get into the federal courts as to whether the tribal court has jurisdiction. That is considered a federal question that we talked about in looking at federal courts in the tribal setting. Bottom one, I think. No.
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 Allow me.
Yes, I will. See, a Mac is good if
Go
you
to
really know how to use it.
slideshow, view show. Okay then. Let's just go to, this will be good. Didn't you have a dance routine or anything?
I didn't.
You were going to do?
I didn't. The other thing that tribes have that I think is different than what you see in the state setting is they do not have some of the same requirements imposed on them because the U.S. Constitution does not apply to tribal courts. Tribal courts predate the Constitution. They are not under the U.S. Constitution. So there are two things in particular that tribal courts do not have that are in the Bill of Rights of the U.S. Constitution, and that is the right to counsel. There's no right to counsel in the tribal setting, and there is also no bar against a tribal religion, so there's no separation between the church and state provision equivalent in the tribal setting. So that's something that's very different. A lot of tribes do have representation in criminal matters, but not all of them do, and once again, it's a funding issue.
I'm almost there.
That next one. Is that it?
That was it.
Okay. Well, that's why. But I did do it right, huh?
Yes. Nice.
How do you select judges for the tribal system?
The tribal systems, they vary. The requirements for a tribal judge can be that you have to be a tribal member. Some of the tribes have that as a requirement, but not all the tribes have that as a requirement. Sometimes they have a requirement that at least one of the judges be law trained, but not all the tribal courts have that as a requirement. Currently, in the tribes in Montana, there is a law-trained judge at Crow. There's a law-trained judge at Rocky Boy. And that is currently it, as far as law-trained judges.
Is it Judge Acevedo? Isn't he a lawyer?
No.
Oh, you know that.
No. Actually, all of the tribes at some point have had law-trained judges for tribal judges, but right now there's been some deaths and fluctuation, and they don't have them as any law-trained judges at all of them. The tribal constitutions or the tribal codes are going to set the requirements for the judges, and that can be varied whether they're elected or appointed. Some of the tribes have them as elected, and some of them have them as appointed. The terms can be anywhere from life to 2 years, 3 years, 4 years, or 6 years. So they vary significantly between the tribal courts as to what those requirements are.
How do you assure quality?
How do you assure quality?
Yes, if they have the ability to do this job.
Well, once again, similar to what they do with the JPs here, they get training. And there is extensive training that the tribal judges have. It's both national and local. So there's the Montana-Wyoming Tribal Judges Association that meets regularly, and they used to meet more regularly when they had funding for it, but they still meet regularly, and that provides training for them. And then there are several national organizations that also provide training for the judges. The quality issue is going to be the same with any kind of elected versus appointed. You have those issues there that you're going to have regardless of who's there, just by the nature of how they get into the office. Their caseloads vary. I think they're probably in some respects similar to what you see in the JP courts. They can have a high number. They may not have quite as many civil cases as you do, although they have a fair number of civil cases. So it just does vary significantly from tribe to tribe as far as their caseload.
The criminal cases, you're not lawyers?
Well,
Where are you?
You know, I guess that doesn't concern me in some regards. They are looking at the law. They're applying the law. A lot of those are going to be, if they're not taken federally, they're going to be handled traditionally, which involve rehabilitation, restitution, restorative justice, those kind of concepts that are incorporated into it, looking at traditional values. So I think there's another way that tribes address that, and they may not be looking at the retribution scheme that you have with the incarceration. They may be looking at what's a different form of justice that's better for the community.
But Maylin and I have both been tribal judges. I've been a trial level judge, Maylin's been a trial level judge, and we've both served on appellate level courts as well within tribal systems. And my first experience on a tribal judge was out in Washington State on the Port Madison Reservation, just in the west part of Puget Sound. And they had a woman who had been the chief tribal trial judge for I think 15 or 16 years, not law trained, and she just did a wonderful, wonderful job, and really a terrific job. And she took advantage of all the training. So my experience really is, and there was a lesser replacement when they took me, but to some extent they were looking for someone who actually wasn't a member of that tribe, because it was such a small tribe that this person knew everybody, and she felt like that was really a difficult part. But they had to make a choice between they had no tribal members at that point who were law trained. So they had to make the choice about having a tribal member be the judge, and she just really did a great job, or having a non-tribal member who was law trained and outside the community. And I think at that point in their history, it worked for them to have me.
A requirement for formal law training for the U.S. Supreme Court.
Exactly so.
Right.
I think Justice Jackson was the last one that didn't have training.
But there is no requirement in the Constitution.
That's right.
Yeah, exactly.
And I will just, along those lines, I will tell you that some of the best judges that I've seen in either state, tribal or federal systems, were tribal judges who did not have law training, that they were the fairest, they basically resolved the issues appropriately, they sort of made what I refer to as sort of restored harmony between the parties, and they were far better than I've seen in a lot of tribal settings where they've actually had law training. I think law training can sort of warp you in some respects.
And so, quite a few.
I'd like to just ask another question. In the last few years, several state legislatures and even Congress have made approaches to actually strip the courts of their right to hear particular kinds of cases. Generally, they refer to it in all the literature as court stripping. That doesn't mean taking all the robes off. But
Derobing.
Thank God. Yeah. Bad visual there.
How do you feel about that? Do you think that's a good thing, that some topics should be not heard by the courts, or that the courts should be able to hear all issues without being limited?
Yeah, you know, I'm not a real fan of the adversarial system, because I will tell you the tribal court system is not real adversarial, and I find things work a lot better in the non-adversarial system. So I think that there are other ways of addressing conflict than making it go through the adversarial system in the district court or JP or municipal courts. So I think that should be encouraged as an alternative, but I would disfavor totally eliminating certain classes.
Yeah, and I guess I go back to the U.S. Constitution that says, you know, in order to have harmony, we actually need, at some point, if these parties cannot come together to an agreement, and I agree that that's preferable, in any court case at all, and you have to say to your client, you know, when we walk into that room and begin the trial process, we are turning your future over to that judge, and we don't know that judge at all. She doesn't know you. all the information the judge is going to get about who was right and wrong, they're going to get in this room, and they don't know the whole history. They can't really tell who's really telling the truth. All they get is what they see here. And so you're really abandoning your right to control what's going to happen because you couldn't agree. If we can, each of us, make some movement towards the middle, and I'll give up something, and I hate giving it up. And Maylin will give up something, and she hates giving it up, but we resolve the case between us. Now we're not at the mercy, where I might win 100%, but I might lose 100%. And the judge might be right, but she might be wrong. And I don't have any say over that. So that's what really the big drive towards alternative dispute resolution is all about. But if we simply cannot agree, then I do think that there just has to be a court system to resolve it where parties saying, we can't agree, now here we are, and we are going to turn it over to the judge and let the chips fall where they may. Far better than the, might makes right.
Do you have other questions?
Okay.
Well, my question relates to part of this about the jury. You haven't really spoken very much about the role of the jury, either in tribal court or state federal court, and what the jury does, and strengths of the jury, and when you wouldn't want a jury. So.
Okay, well, I'm an enormous fan of the jury system, and I believe totally in the ability of 12 or 6 people drawn from the community without warping of law training, generally. And I think it's true that all lawyers, at least all trial lawyers, desperately want to be on a jury. I'd give anything to be on a jury. Of course, we're never called, and if we're called, we're immediately struck. So I'll never have that wish. And so when I hear people say, how do you get out of jury duty? I'm thinking, you're crazy. Can I take your place? Can I have your false ID and go on in there? But
John Mudd's on one right now.
is he? Yeah, we'll see some probably less controversial lawyers, yeah, probably. But I think that the jury really does the job that it's supposed to do, which is to find the facts in the case, and that the jurors are more qualified than a law-trained judge to do that, or than any judge who sees these cases day in and day out. But of course, you only get the right to a jury in certain cases, in criminal cases. On the civil side, though, only in those cases which used to be classified as cases at law. So like injunctions and so on, we assign that job to both finding the fact and applying the law to the judge without a jury. But otherwise, each party in a civil case has the right to ask for, and if you ask correctly, to have a jury, so long as your case is at common law, worth more than $20. And we've already covered that, right? If you have a case less than $20, what should you do? Go home. Right? Do not.
Don't take it to
Don't
JP
take
court,
that
right?
case to court. But otherwise, for more than $20, you have a constitutional right to a jury. And there are all sorts of schools of thought among trial lawyers, of whom I'm one, to, when do you want a jury, when don't you want a jury? But no sooner do you make a generalization about jurors are good for this kind of party, then you know what, your pool of 12 doesn't necessarily bear that out, and you're always shooting in the dark about that. But almost every trial lawyer I know believes totally in the jury system and would generally rather try the case to a jury than just to the judge. Does that answer your question?
In tribal courts, you have basically it's the same. You have a right. There's only 6 members that are required on the jury in the tribal for criminal matters. For civil matters, you may be entitled to a jury trial, but often the tribal code will have some dollar restriction that has to be amount over a certain amount that you're asking for. My experience has been you have less jury trials in the tribal system than you do in the state system. And I think there may be some change where you are getting more, but because most of them are pro se, they don't have representation, they're less inclined, I think, to ask for jurors, to have jury trial.
On the other hand, when I ran a couple of jury trials when I was a tribal judge out in Washington, and a couple of funny things. We ran them on Saturdays by tribal code so that the tribal members who were jury members wouldn't have to lose any work time. So we convened on a Saturday, and it was a shellfishing tribe, so it was a shellfishing violation. And the shellfishing police, the game officer who came in to testify, came in, and he was sitting there, and then the jury came in, the people who were up for voir dire came in, and I looked and I thought, oh, that guy, who was his identical twin brother, was sitting there, what's going on here, he can't testify, he can't be in the jury. Well, it's not him, it's his brother. Well, just as in any other jury system, that was too close for comfort, so away he had to go. But that was a pro se, a defendant accused of shellfishing without a license who represented herself. And I thought, oh, this is going to be a disaster, this case. She's not going to know how to do it. She must have watched a whole hell of a lot of TV, because she ran that trial as well as any lawyer that I have ever seen. She did a great opening, she did great direct, she did a great cross. And in the end, however, she was convicted. And what was interesting about that was, how in the O.J. trial they were trying so hard to get jurors who had never heard of O.J. Simpson. Well, you'd have to live under a rock in this country to not have heard of O.J. Simpson. So you're selecting people who aren't all that interested in what's going on. In that case, when I talked to the jurors afterwards and said, why did you convict her? She said she didn't do it. And they said, this is a small town. This is a small reservation. We've known that girl since she was 2, and she's lied from that day to this. There is a lot to be said for that. And that model is a lot closer to the oldie Englandy model when we were talking about, jury of your peers was jury of your 12 closest neighbors, and they knew, and they brought all of that with them, and they got to the right result. And I thought, I was a judge. I didn't know her. Hell, I kind of believed her. And,
But that is the times that I've had jury trials in tribal court. Getting a juror is much more difficult because they're all related. So figuring out whether they're far enough not related that they're willing to sit on the jury is going to be a challenge.
In the early English system,
Right.
the jurors had to say that they knew both
Right.
parties.
That was the whole point of the jury. And so really, as we've stepped away from that in the bigger cities, we've lost a lot of the good of the jury system. And so in a way, it's ironic that some tribes have set up the same sort of distancing of the jury from the parties. Now, it's uncomfortable, I think, to be a juror and to have to look your good friend or neighbor in the face and say, you know what, you're lying, and we know you did it, and you have to go to jail for this. But nonetheless, that was how it was originally contemplated.
And I had a tribal jury that believed him but wouldn't convict for those very reasons.
Yeah. So.
Are there other questions? Would you take just a minute and...
You've got another question?
Good.
Are you doing the mic? It's already on.
It's on.
Yeah.
Is it on?
Yeah.
I've seen or heard of many cases where defendant will, or the defending lawyer will bring up the Constitution in court, be it a tax court, district court, or whatever, and the judge will say, if you bring up the Constitution in my courtroom, I'll have you in contempt of the court. Can you explain that to me?
Well, every judge is sworn to uphold the Constitution, so it's certainly not that the Constitution is irrelevant. In the exact, and it's hard to tell, which we haven't gone through, is the phases of the trial, and I'm certainly happy to explain that in the remaining time. But there are times and places in the trial when you're allowed and supposed to argue about the law and how it applies. And of course, the Constitution is just the supreme form of the law. So if we're in the phase of the trial where we're talking about, what happened and whose car went through which intersection with which light, the Constitution isn't relevant at that point. If there's a constitutional provision that's bearing on what's happening, in terms of once the facts have been found, they should come through the judge in the form of the jury instructions, which he or she gives to the jury. But then the lawyers do have a chance at the closing argument to comment on the law, to say how the law applies and how the jury should use that law together with these facts to come to the result that they're supposed to. So maybe it's just a timing issue, and I myself have never seen that. I would probably gasp, I think, if I saw it, but in a particular situation, I can see where maybe that would happen.
Yeah, I actually saw that in a tax court. The defendant, actually, he stood up and he opted not to testify because he didn't feel that he would be fairly treated. And he read a statement, and in that statement he said, I have been instructed not to bring up the Constitution. I don't agree with that, but I have no choice but to respect that.
Huh. Oh, I can't explain that, except that if the judge was saying, this is a question of fact and I want to know what happened, that's different from the Constitution. But at some point, you always are given a chance, in my experience, to argue the law in your closing argument. So that's all I would know about that.
Other questions?
What about tax judges? Are they aren't required to have a law degree, right?
Tax judges are required to have a law degree, for sure.
My husband was a law judge, and he was not a...
Oh, an administrative law judge,
Administrative
that's a
law
different
judge, yeah.
thing. Do you want to go ahead?
Go ahead.
So tax court judges, that's what I was thinking
Oh, I
of.
see.
Yes, federal tax court judges, they're all law trained and appointed and so
So
forth.
with that, in that case, somebody was kind of...
Yeah, I don't know what level that was, but it could have been an administrative law judge. There is another level of judges out there that are administrative law judges in the federal system that basically address code of regulation or just violations of a code that don't necessarily deal with factual determinations to the degree that you have them in the other court settings.
Yeah.
Yeah, and for instance, Social Security cases, if you apply for Social Security and you're turned down, your first step is in front of an administrative law judge, long before you have to process through that, long before you can go anywhere else. And those judges generally are not law trained,
Right.
although there are.
There are,
You know,
but,
he was required to get quite a lot of training.
Right.
Went in Las Vegas and Chicago and all over the place.
He told you that he was going to Las Vegas to get law training?
I went to Reno. But they do have a big judicial training center in Reno. Yeah, Las Vegas, they just have the slots. Sorry. No, it's okay. It was a When Boyce was here last week speaking at law school,
Yes.
he said that he felt, given a choice, he would have no judges elected at any level. He would have them all appointed. How do you come down on that?
Yeah, I was interested that you asked that question. I was glad that you asked that question at that time, moment in time, and that we moved into that discussion. I guess I think it's 6 of one, half dozen of another. I think that either way you get on the bench is political. One way is clearly political, you're running, but you're running. It's so, everybody knows that's how it happens. The federal judicial appointments, or even state judicial appointments, you're not just appointed out of nowhere. They don't just go down through the book and say, oh, good, how about you be the judge? Yeah, generally there's an application part, and then there's a lot of power play behind the scenes about who gets to be the judge and who does not. On the other hand, we've all experienced and there's several lawyers in this room, we've all experienced right before judicial elections, people call us up and say, whom should I vote for? And I used to think, that's actually not how you make a decision about whom to vote for. I can tell you the good things and the bad things about each person. And finally I came to where I learned they didn't much care. They didn't want it reasoned out. They didn't want to make their own decision. They wanted me to say whom I was voting for, and then as far as I could tell, they were going to go vote for the exact same person. So that's not exactly what we mean by electing either. But again, you all coming to this seminar and finding out what the courts do and what the right sort of qualifications are, whether a person's law trained or not, whether there's good judicial temperament, whether they're hardworking. One of the only slide I didn't put up was removal of judges. And the Supreme Court in the state of Montana does have the power to remove judges, but it happens so rarely, so rarely. And we've had an example of that from down the Bitterroot just recently. But I guess where I was going was, either way, there's a huge amount of political, sort of generally elected action going on, and I don't have a preference.
And I guess I would say, in some respects, I think election is better if the term that they're elected for is long enough in duration that they're not constantly having to run for re-election again.
Yeah. How many in this room are attorneys?
1, 2.
And actually, Brenda and Karen, this is Brenda Desmond, Special Master for the Federal District, or for the State District Court. She is one of the candidates for Judge Henson's seat, and Karen Townsend, the Deputy Criminal Prosecutor, Chief Deputy Criminal Prosecutor, is the other. Judge Orzik runs...
But she's not an attorney.
No, she's not an attorney, but she's a judge. So, and... Yep.
How many?
Right.
I think there's 6
1, 2,
altogether.
3, 4,
There's 6.
6. Abe, you're not.
Too bad that more just regular citizens wouldn't come.
It's very hard to find this place. There's all sorts of people wandering around trying to find out who's supposed to. Most of them just.
Oh, is that right?
Yeah.
Huh.
We'll try to get them here next time. I think we probably have time for one more question if someone has one.
I don't Yes, I'm interested in the extent and the types of cases that the tribal traditions or customs are used in making the decisions in the court.
You know, they're going to come up in, probably any type of case you have, but they're sort of going to be handled below the radar screen usually, so they don't even actually get into the formal court setting. They're going to be handled by the tribal societies, the tribal clans, so they're handled outside of the adversarial judicial system most frequently, and then those that do get into the judicial system are primarily going to be those cases where they involve two tribal members, so that the judge knows that these are individuals who should know what tribal customs and traditions are. I know a judge from Crow was talking about having a case where one time he went into speaking Crow to the clients, and the attorney sort of got concerned about this, but he was basically telling them at that time, this is what tribal custom and tradition is, and you're forgetting this. So he said I had to remind them of what their tribal customs and traditions were, because the way they're behaving indicated that they'd forgotten that.
And what kind of a case was that?
It was a family law dispute.
Yeah.
But it can be anything. It can be a civil issue or anything, but it's more who the parties are as opposed to the type of case it is, as to how I think the judge is going to. And would you agree with that, Brenda?
I would, completely.
But the Confederated Salish and Kootenai Tribal Code specifically says the law that's going to be applied in the court, in all cases in these courts, is first our law, then if there's nothing here, if there's federal law that's corresponding or state law, we'll look at that, but it also specifically says, and tribal custom in a particular case. So you present that any way that you want to, I would think. And I've seen some trial lawyers talking about hiring native elders from that particular tribe to come and actually testify about what the custom has been if it's not so generally known.
What are examples of customs?
Well, you know, one of the things that I think where in the family law area, we have, in the state system, you have these child support guidelines that you have to go through all these steps. Tribal courts don't apply those, and so you may get things like you have to provide them, you know, elk or 5 cords of wood or those kind of things that are looking at other resources and not just making it a dollar amount that they have to pay by a certain time of a month kind of thing. So that's part of it. And the other thing is that you have things like talking circles or restorative justice where they have to go out and work with the elders and help in the communities. So there are other resources that they utilize under tribal customs and traditions to address those.
Can they ban people from the reservation?
You know, they can ban people from the reservation. That isn't used that much, partly because the problem is if they come back, then the tribe's stuck because they can't do anything criminally with the individual. And so you set up this situation where it's not real effective to banish somebody, but they have that right.
And those 2 boys in Alaska a few years ago, didn't they take them out to an island? And
Yeah, that was hugely controversial because the issue is those are 2 people that really had the authority of the tribe to be doing that. So.
But that was at least a cover under which they were trying
That's
to do
right.
What tribes have pecking orders?
They do.
And it's,
Yeah.
I know my cousin came to school here, and then when she went back to Browning, she said she had to get into so many fights because she had to reestablish her order.
Well, yeah.
But my small boy had to do that same thing over at the Mount Jumbo elementary playground, I gotta tell you.
Yeah.
Okay.
Judge? Oh, I'm sorry.
Did you have a question, Judge?
I just wanted to make a couple comments about adversarial system. In my civil cases that I have, the first thing that happens is a pretrial, and people are ordered to mediation. And as you said, if people come to their own decision and they don't put it in my hands, it's actually a good thing because I can't try 5,500 cases a year. So when they go to mediation, it's important to be persuasive at that point in time and say to the plaintiff, you know, if you don't come to mediation, the case is dismissed, and you tell the defendant, and if you don't come to mediation, the plaintiff gets judgment in full, and either one or both of you are going to be very disappointed in the decision that I make, because it's not going to be an agreement between the two of you. And so at that point, it's not so adversarial because 80 to 90% of my cases settle when they go to mediation.
Right.
They have professional mediators in there, and they're just suing each other because they quit talking. And if you can open up the doors to conversation again, maybe they can come to their own settlement. So to define the state system or as an always adversarial system, yes, it is. But the prosecutor and the public defender engage in settling cases, and it's at that point it's not so adversarial. Yes, it is when it goes to court. Okay, yes, it is, because I'm going to make this decision, and you put that power in my hand at that time, and that's what I'm there for. But a lot of it is a restorative type justice and having people come to their own decisions about where to go.
And that certainly is what mediation is designed to do.
Yeah, exactly.
So, yeah, I mean, and I'm a big fan of mediation.
Oh, yeah.
Yeah, because it does just that. It's that more restorative justice. And you don't have two people that may leave, but one of them happy, one of them sad, that still hate each other.
Yes.
Hopefully they are talking by the time they're done with mediation.
And I think the difference in the statistics, how many settle in mediation at your level, as opposed to that very small number, really, that we saw in the Supreme Court, is by the time they got to the Supreme Court, they've already invested in the act. Maybe they've already been through some settlement thing. They've had a trial. They've invested, and now somebody's won and somebody's lost, and they're past where they're going to settle. So at the beginning of the lawsuit is much more likely than at the end. And I actually have a case where a guy said, well, why don't we see what the Court of Appeals says, and then we'll see about settling. And I'm thinking, well, when they ruled, that's the end of the story. So if I won, I'm so not settling with you. And if you won, I'm pretty sure you're not going to settle with me either. The time to settle is before you get there. Yeah.
Okay, thanks for coming. I appreciate you all coming and participating. I hope some of you will come back for the second session. There's a little evaluation sheet on your chair or on a chair close to you. If you take just a couple of minutes and circle the numbers and leave them on that table outside as you go, and hopefully we'll see you for the other two sessions. And thank you very much to Professor Ford and Professor Smith.